Friday, Southern District of Illinois federal judge Stephen McGlynn heard from litigants about the state's gun and magazine ban, and on the merits, they're moving forward. While the state wanted to wrap up discovery in November, the plaintiffs wanted to wrap up discovery in July, and the judge declaring that they have no interest in delaying this case any further. Welcome back. It's Bishop on Air. I'm your host, Greg Bishop. Thanks for hanging out. You can check us out each and every weekday morning here about this time. A little later getting started just because I had a couple of interviews that had to happen earlier than later. So here we are making that happen for you. But we'll get to those a little bit later on. Let's focus in on what's going on at the Southern District of Illinois Federal Court. Before so, though, let's take a look at the latest in gun registration data. Let me pull this up from the Illinois State Police website where you can see this yourself. I have this saved from the last time we did this update. And you'll see of 2.4 million firearm owner identification card holders, around 29,357 registered firearms before the January 1st deadline, and between January 1st and January 23rd, 6,074 additional people registered. But let's refresh, and you'll see that it has jumped up to 6,262 now have registered after the deadline of January 1st. And you can see the breakdown there of the number of firearms that were registered and the total number of accessories and so on. But what's interesting is, and you're seeing people point this out more and more, we've touched on it briefly, we have not seen this 2.4 million FOID card holder number increase since we've been checking these numbers out from October 1st until now. And when you go and you actually look further, you can see that while this number has not changed in the past 5 months or so, the 2.4 million, just in the last quarter of 2023, you have the number of new FOID applications that are approved at more than 45,000 just in 3 months' time. And I went ahead and added all these up, and it looks like it's well over 100,000. I think it was close to 200,000. But obviously, you've got the FOID cards number might not be accurate. So while we say that it's 1.47% of FOID card holders who have actually registered, the total number of FOID cards has not been updated on the ISP's website for quite some time. For all of 23, ISP data shows 158,823 new FOID card applicants that were approved. So maybe the percentage is much lower. Regardless, I just wanted to get that as kind of a placeholder here as we talk about what happened at the Southern District of Illinois Federal Court. And if you follow me on X, you were able to see these posts in some more detail, really when it comes to what the judge's sentiments are. And I think that that's extremely important. But here's just some of the encapsulation of those tweets I sent out. You had the Barnett attorney essentially come out and say that they heard the judge loud and clear that it's time for these lawyers to no longer be lawyers by filing briefs, but actually to be trial lawyers. And what needs to be proved from the Seventh Circuit opinion, the Barnett plaintiff said, is how it differs from different cases in the district court and the factual questions from the appeals court. So the state put for the schedule to extend in the fall, says that the plaintiffs haven't been on the same page, and they understand that to move quickly for final resolution, they haven't been able to make a headway with the state on a schedule. They said, quote, the Barnett attorney said, "We're here to work with your honor to find out how to move things along as expeditiously as possible, but understand this is unique in light of the Seventh Circuit standard." And I think that Seventh Circuit standard you're going to hear a lot more about as we delve into this more and more. But the judge went on to ask other plaintiffs what issues should be discussed. No one else spoke up. So the judge went ahead and said, okay, firearms that are commonly held, owned, there's a lot that's in the record already. And the judge went on to say maybe some of the plaintiffs that are sellers of firearms can testify that these are weapons that we hold out for sale, and there's already a market for purchasing those by people who own firearm owner identification cards that pass background checks. There's a market for this, the judge said. People in Illinois are buying these guns. The Seventh Circuit talked about 24 million versus some other number, And the judge said, to be candid, we know that there is a sufficient number of AR-15s and other semi-automatic rifles sold in Illinois to holders of FOID cards, and that they possessed them legally before the enactment of the statute, the judge said. I don't think it's going to be a tough hurdle to climb for these. Now, he also said the AR-15s may not be widely held, but there could be copycats and knockoffs, he says. But do we think that there will be meaningful contests, that there's enough numbers of AR-15s? That is not nominal. So again, commonly owned. What's commonly owned? I think that the judge really trying to get to the crux of that. There was also discussion about self-defense, and does that happen outside the home? What are the characteristics of legal self-defense, and so on. The Federal Firearms Licensees of Illinois attorney went on to say that all they need to do is look at whether semi-automatic center-fire rifles with detachable magazines, and whether that as a group, as a category, are protected arms or not. And this really deals with what the state was getting after. The state was trying to say time and again, we're just trying to find out what the plaintiffs are aiming for. Pun intended? I don't know, but that's what, a quote that the state lawyer had to say. They need to know what they're aiming at because they want to bring a proper defense. Well, you then had the judge say that he's not interested in delaying this case any further for any length of time so that the government can figure out what they've passed. So again, back to the FFL of IL, they said they don't need to go through every firearm, but making make and model, because unless the state can identify some material difference in those models that would make a difference in the legal analysis, if all we need to do is say such things as a category, we think we don't need to litigate every make and model. We just need to litigate the category. And apparently they've looking at 9 different categories, and you got to think what are those categories: center fire, magazine-fed long rifles, semi-automatic handguns with threaded barrels, other types of long guns, other types of shotguns. You can kind of go through and just start thinking about the different categories. And really what they're looking at doing is trying to butt that up against the 7th Circuit Court of Appeals ruling, where they started working in, the question of, was it meant for the military or not? And again, whether or not the 7th Circuit got their analysis correct under the Bruin standard, that's something else that we'll have to evaluate at a later date whenever they get this case from the Southern District, which ultimately could go all the way to the U.S. Supreme Court, which is expected. But again, Judge McGlynn saying that he's not interested in delaying the case at all, saying that he doesn't want to give the government more time to figure out what they've passed. McGlynn also went on to say that this is a very important matter. He said the claimants believe that their constitutional rights have been imperiled, and so it's the court's belief that I should try to work through with as much dispatch as possible. Understand that we want to get right with all the record, and whether discovery needs to be exchanged can be exchanged, but also understanding that in these cases there isn't a lot of prolonged and protracted discovery, meaning he wants to get to the merits of this quickly. All right, so that's a little bit of a review of the hearing. They're going to come back on Tuesday. The plaintiffs have to file with the judge saying these are the representatives we want for our consolidated case. So that's who's going to be working on the deposition and discovery timeline. And the depositions are interviews with witnesses and experts, and the discovery is trying to find all the evidence, get all the evidence together. Because in a trial, the defense has to know everything that the plaintiffs know, and the plaintiffs have to know everything the defense knows, and then they make their arguments. So that's what the discovery is finding all of those pieces of evidence. But I connected with Todd Vandermyde, gun rights advocate, Freedom's Steel here on YouTube, and got his take because he was in on that call. He's been what would you call a consultant for the Federal Firearms Licensees of Illinois plaintiffs. And here's his impressions of how this went down on Friday.
So I think there are some unique takeaways from what we heard at the status conference. The judge seems to have his finger on the pulse that the state passed an absolute shit show of a statute, and the government lawyers are playing catch up to try to understand the technicalities and how broad it is. And I think he kind of pinned them on that, thinking that there should be a legislative record to combat this. If you listen to some of the debates that have happened with former Representative Mazzocchi, who was a trial lawyer, who sat there and told some of these people, and they're passing various anti-gun bills, that they didn't develop a record. What record do you have to sustain this in court? And the anti-gun legislators are just too lazy. They think they got the rule of 60 and the rule of 30 in the Senate, and that's all they need. They don't have to justify themselves. And I think the judges caught on to that, the lawyers representing their clients may be behind a power curve because they don't have the record that the judge thinks they would have built if they were going to sit there and tackle a constitutional issue like this that had been before the court on 4 separate occasions, that they would turn around and build a robust record from which the state could defend it. And they didn't do that. They just said it's going to pass muster, the end. And so I think the judge caught that was one particular takeaway. I think the state proposing a schedule that lasts into and beyond the first of next year. I mean, we're just closing up discovery in November, and they're going to want another 30 days on briefs, 60 days on briefs, and then however long a trial is. And the judge wasn't buying that either. He thinks that constitutional rights are being violated, or at least that is in the pleadings, and therefore he wants to see a quick remedy to this to get this on and up. And I think that the state is they're still pole vaulting over mouse poop because they wanted to have an argument today about standing. And you would think that we are well past the standing relevance at this point in time. If we didn't have standing to bring a preliminary injunction, then how do we, and we surpassed that hurdle, then how do we not have standing to sue the state? But it sounds like that they want us to provide 200 plaintiffs. They're going to sit there and say, I want to buy a gun, this particular gun by pick a manufacturer, Stag Arms, Rock River, Colt, Sig Arms, whoever, and go through, I want to buy one of these and now I can't, through that entire list of firearms. And we were trying to get them to narrow it down to, say, 9 categories, like magazine-fed semi-autos, and they're still arguing that, well, now we have to prove standing that we have to have somebody who wants to buy a 1911 with a threaded barrel or a Glock 19 with a threaded barrel or whatever. And I think it goes to the ridiculousness that they don't want to argue on the merits. They think we're going to pull something, out of thin air like a magic trick is some gotcha moment when, we've got the facts in the Supreme Court on our side. There's no gotcha. You're just arguing from a position of weakness, and you're trying to formulate. I mean, you've heard Tom DeVore sit there and say that the AG's office simply pulled this training thing for wardens out of thin air. I think they know they're behind the power curve. I think that they know that they don't have a judge who just bends over to the state at any whim, because he's obviously kept us on a tight schedule, and the state filed this status report with their preferred schedule and asking for a magistrate. And again, the judge shot him down, said, this ain't going in front of a magistrate. This is going to be in front of me. And I think he's going to have a discovery status call on what we actually need to ferret out. I think based on listening to him, he thinks we can do the majority of this on paper, that we don't need a boatload of experts and all that kind of stuff. I think he doesn't believe we probably need a lot of depositions. It sounds like he has been reading these cases from across the country and has seen how other states or other jurisdictions have handled this.
Again, that's Todd Vandermyde, gun rights advocate, longtime former NRA lobbyist, consultant for federal firearms licensees of Illinois, listening in and getting the latest on the case in the Southern District of Illinois Federal Court. So we'll see where that goes. Again, Tomorrow, the plaintiffs have to tell the judge who exactly is going to be representing those individuals in front of the judge. So clearly, a lot more to be said about all of that here in the near future. But you've also got this other case in the Southern District of Illinois, which we don't have time to tackle today, but we will tomorrow, and that's the United States versus Bernard Cherry, where a former felon wanting to exercise their Second Amendment rights appears to have gotten a victory in the Southern District. So we'll touch on that tomorrow. But some of the latest in the litigation against Illinois' gun and magazine ban, right here with Bishop on Air.